its business for about 16 years, representing both non-federal governmental plans and ERISA plans. So I have a background in this. Thank you for spending your time with me today. I'm glad you could join me for my overview of compliance with the new 2021 COBRA Subsidy rules. Whoops. We're going to get this switch right. There we go. Before we begin, I have to give you the standard disclaimer. This presentation is for informational purposes only and does not constitute legal advice or tax advice. Please discuss the issues raised here with your plan legal and benefit consultants to determine how the issues apply to your specific situation. The information that's in this presentation is subject to change as more guidance becomes available. All right, having dispensed with that, here's an overview of where we're going today. And before we begin, I'm reasonably sure that once we get into this, you're going to think that there is a lot of information, and I hope you're not overwhelmed. My goal today is not to make you subject matter experts in everything having to do with COBRA and the subsidy. Really, what I want you to walk away with is enough of an understanding so that when you go into compliance mode with your plan advisors, you have enough knowledge to ask the right questions. You'll have this to refer to, but really you need to know what to ask about, let's say, handing out notices, etc. So please don't become overwhelmed, and please just keep in mind that I only expect you to have good questions at the end. And also, there may be questions that I can't answer. And that would be because there's no guidance yet. And as you'll see as we get into this, there are a lot of open questions that need to be addressed. So without further ado, COBRA basics. You're going to have to know your COBRA basics, otherwise you won't have an understanding of the subsidy. So I'm going to go into a very high level review of how COBRA works. Of course, being an attorney, I have to say that this is a very complicated area. There are nuances and there are situations where the rules change. So we're not going to get caught in the weeds. I'm only going to take you through what you need to know, but be aware that it's not a one size fit all when it comes to COBRA. So the COBRA comes from the Consolidated Omnibus Budget Reconciliation Act. And I actually had to look at my notes to read that out. Most attorneys only go by acronyms, and it's fine to just know that it's COBRA. And it gives employees and their families the option of continuing their coverage under their employer's healthcare plan. And that's only for a limited period of time. And that happens when they experience a qualifying event. Now, federal COBRA doesn't apply to employers with 20 employees or fewer. So if you're a small employer, you have fewer than 20 employees, federal COBRA is not going to apply to you. Now, that said, if you are a small employer in a state like California or Arizona, you're going to be subject to what are usually called state mini COBRA laws. So that's how some states like California and Arizona sweep in these small employers so that people in their plans have the option of continuing coverage after a qualifying event. So plans covered by COBRA. Now you'll have to bear with me here. I thought I'd be able to see my notes as we presented, but I was a little off on that one. So COBRA covers health plans, dental plans, vision plans, and prescription drug plans. So anything that you would typically think is a health plan intuitively is covered by COBRA: health, vision, dental, and prescription drugs. Now, it does exclude coverage or continuation coverage for certain things. Basically, plans that only offer, let's say, life insurance or disability benefits, medical savings accounts, things that don't actually provide a whole lot of benefits, but insure certain parts of them. Those are not qualified for COBRA. They're not covered by COBRA. So one thing that I get a lot of questions on from my clients is, well, what do people in COBRA who have elected it and are in the COBRA system entitled to? And it has to be identical to the coverage that you offer any similarly situated individual. So they have to have the same co-pays, the same deductibles, same benefit limitations, and open enrollments. So any modification to coverage or similarly situated active employees, it has to be made for COBRA beneficiaries. It has to be the same. Sorry, I'm being distracted by the door opening buzzer that is set up in this office. So that's basically what you have. Again, there's always different things that apply, but in general, there you go. So who's qualified for COBRA? So when you qualify for COBRA, you're called a qualified beneficiary, so a QB. So wherever you see a QB in this presentation, know that I'm referring to a qualified beneficiary. So who does that include? Well, off the bat, it's the employee. We all know that employees have benefits and they're going to, in some cases, want to elect COBRA. This also includes the employee's spouse and the employee's dependent children up to the age of 26, remembering that the Affordable Care Act extended the age to 26. And this also includes any child born or placed for adoption during the COBRA period. So you could actually have another qualified beneficiary come on board while the other qualified beneficiaries are in COBRA. Now, in order to get COBRA, you have to have been enrolled in the employer's plan prior to the qualifying event, and we'll get to those, but you had to have been in the plan beforehand. So keep that in mind as we go into the subsidy. If you weren't in the plan, you can't elect COBRA, and if you weren't in the plan, you can't elect the subsidy. So that's something important to remember. So let's go into what keys off a COBRA event. So a qualifying event, again, I'm going to go with an acronym here, is a QE. So wherever you see QE, we're talking about qualifying events. So for the employee, a qualifying event includes a termination of employment. That's a pretty simple one. Now, for COBRA purposes and later on for the subsidy purposes, a termination of employment excludes gross negligence. Now, gross negligence is a very subjective term. Now, it can be, I think the most extreme case I've ever seen is someone who threw a chair at their manager. That would be gross negligence leading to termination, and that means that person would not be qualified for COBRA. Some other things that you might want to keep in mind for gross negligence is fraud, theft, physical violence, drug abuse, and the severity to the company has to be more than just cause. So we'll move on from there. Also, for the spouses and dependents, an employee's termination, again, excluding gross negligence, employee's reduction in hours, an employee's death, an employee becoming entitled to Medicare, divorce, legal separation, and then for a dependent child when they age out of the system. Now, the length of COBRA can be a little complicated, but we're going to do as high level of an explanation that we can. So employee, by and large, with one exception that we're going to go into, has 18 months. That's it. They get 18 months of coverage. A spouse or dependent child starts out with 18 months for coverage. But for spouses and dependent children, the original 18 months can be extended another 18 months for a total of 36 months. And this is going to be important to keep in mind going forward. So in order to get that other extension, they had to have elected COBRA. So they have to be in COBRA. And it has to happen within that first 18-month period. And so that second qualifying event would be anything that would have caused them to lose COBRA coverage in the first place, even if they weren't already in COBRA. So again, it would be the death of an employee, a divorce, a legal separation, or a dependent child reaching the age of 26. And again, another one of those interesting exceptions. You can also get 36 months because of employees' enrollment in Medicare while employed. but that's a special rule and we're not going to go into that. Now, the one way that I was talking about an employee getting extra time on their COBRA is for disability. If one qualified beneficiary, any of them, is determined to be disabled by the Social Security Administration, the SSA, within the first 60 days of the COBRA period, then all of the qualified beneficiaries receive an extra 11-month extension for a total of 29 months. So that's pretty much the only time the employee is going to get more than 18 months. All right, so I stole this table from the Department of Labor and I updated it just a little bit. It's a nice, just sort of one-stop shop for figuring out how much time someone has while they're in COBRA. So again, for the employee, termination for reasons other than gross misconduct and a reduction of hours, the qualifying beneficiaries for that are the employee, the spouse, and the dependent child. And for the employee, that's a max of 18 months, but it can be extended based on disability to 29 months. Now, if we have a second qualifying event, again, employee enrollment in Medicare, divorce or legal separation, death of employee, then we go up to 36 months. And I want to point out for divorce or legal separation, that normally wouldn't.
Also called out Kevin McCarthy and said that he changed his position, which he did after Donald Trump initially in the aftermath of January 6th.
Can we have everyone turn off their or mute themselves, please?
What? One thing is we gaining the House majority next year. His calculation.
Getting feedback from the background. There we go. A dependent child typically wouldn't be eligible for the extension if it was a divorce or legal separation as a second qualifying event, typically because plans don't terminate dependent children when there's a divorce, there's legal separation. Remember, it had to be an event that would have caused them to lose coverage independent of COBRA. So for the divorce or legal separation, it's really going to be 36 months for the spouse. Okay, so in general, your COBRA period ends when the maximum COBRA period expires. When you hit that 18 months, 36 months, it's over. Now, can it terminate earlier? Yeah, it can. It can be terminated by the employer when premiums aren't paid in full on a timely basis. You're not required to keep them on the plan if they're not paying their premium. Similarly, if the employer ceases to maintain any group health plan, you terminate the group health plan, and that feeds back into treating all similarly situated people exactly the same. And then it terminates if a qualified beneficiary begins coverage under another group health plan after electing COBRA. Now, a couple of things here. When it comes to Medicare, you're going to see the words entitled and enrolled, and they don't mean eligible and entitled. They're not going to mean exactly the same thing. To be eligible means you could enroll in Medicare. To be entitled means you are in Medicare, and it's a way of making things a lot more confusing than it has to be. And that's going to be an important difference. Under regular COBRA, you lose your COBRA coverage if you enroll in Medicare, so you're entitled to Medicare. When we come to the subsidy, it's going to be a little bit of a different story, and I'll cover that when we get there. Again, I jumped the gun a little bit on that entitled. And then they can lose their coverage early if they engage in fraud or any other conduct that would justify terminating their coverage if they were enrolled in the plan outside of COBRA. For example, they enrolled someone in COBRA who wasn't eligible, such as a cousin, and just claimed them as a dependent child. That would be an example of fraud that would terminate COBRA. And then if the COBRA coverage is terminated early, there has to be a notice provided to the qualified beneficiary that their COBRA coverage is ending. And you're going to see this again coming up, so keep that in mind. So what does a COBRA cost? COBRA is fairly expensive. The employee or former employee who elects COBRA is going to pay 100% of the employer cost plus a 2% administrative fee. Now, I'm going to give a very simple example, which we all wish was the case, but it's not. So let's say the employee pays $50 and the employer pays $50. The employee under COBRA is going to pay that full 100 plus a 2%. So really, it's all on the employee at this point. Now, we talked about that 11-month disability extension. Now that goes up to 150%. So it's going to be quite expensive, which is why generally people who have option to cheaper access to cheaper coverage are not going to take COBRA. The people who take COBRA by and large are people who need the coverage. So they tend to be a little bit more expensive, whereas people who have fewer needs are going to maybe perhaps go out to the individual marketplace or enroll in the federal marketplace. So there are notice requirements, and these are important to keep in mind because these are going to apply to the subsidy notices when we get to them. You have to give notice to the spouse and each dependent covered under the plan because they all have an independent right to elect COBRA. They don't have to, but if this employer does, the employee doesn't have to, but the spouse might. So they all have an independent right, which means they all need notice. Now, if you provide notice to the spouse and there are people living in the same house, I'm assuming minor children, that's considered notice to all the other qualifying beneficiaries in the house. But if you know that there are qualifying beneficiaries who don't live at the same address, you have to send them notice as well. And these notices have to, they're statutorily required language that has to go into the notices. Now, best practice is to use the DOL model COBRA notices, and those are available on their website. And if you use the most recent DOL model COBRA notices, you're considered by the DOL to be in good faith compliance. Now, having said that, I need to point out for non-federal governmental plans, typically they're governed by Department of Health and Human Services, but in this case, they may also use the DOL model and be considered in compliance with COBRA notice requirements. Now, if you send one notice to all the qualified beneficiaries in the same address, then you have to identify each of them separately and identify and explain that they have a separate and independent right to elect COBRA. They have to know that even if everyone else in their house doesn't, they can go ahead and elect COBRA. But still, even if you know all these QBs live in one house, if there's a child in college who lives somewhere else, that child has to get their own separate notice. And then unless the election specifies that it's for self-only coverage, an election by an employee will be considered an election for any other qualified beneficiary who would also lose coverage. And that typically would mean dependent children. Oops, that's not, there we go. Now, this is also very important. There's been a lot of lawsuits and a lot of lawsuits sent around this. Typically because someone will say, I never got my election notice. And so I would have elected COBRA if you had told me that I could have. And that ends up in court a lot. So under the statute, you have to provide this in person or by first class mail at the last known address. That is something that I strongly suggest you document. I've seen records where employers write the date that it was sent, the way it was sent, and the address it was sent, and just sort of check a box so that if someone comes back and say, well, here we did it first class to your last known address. And typically that's okay. Now that we're in this work from home electronic age, a very good question that comes up is, can I send this by email electronically? Absolutely, you can. But because there's a whole lot of rules and the government typically wants to guarantee that there's an actual receipt, there are a number of requirements that you have to meet under ERISA for the electronic provision of plan documents. So you're going to have to look into those first. Now, for my non-federal governmental plans that aren't subject to ERISA, these serve as a best practices, where you don't have to do it, but it's a good idea that you do it so that if anything comes up, you can say, look, I used a bright line. I used a best practice. And then I repeated document, document, document down at the bottom. And I could have fit more, but I thought that'd be overkill. But really, you need to document how and when and to whom notice was sent. And that takes us right into the COBRA penalties. So there are a number of penalties that can apply. There's an IRS excise tax of $100 a day per beneficiary, capped at $200 for family, for noncompliance, and this includes notice deficiencies, going back to document, document, document. And then if you're an ARRA plan, there are notice penalties of $110 per day from the date of the compliance failure, and these aren't exclusive. All of these can be levied. And then you have the possibility of an individual or class action lawsuit under ARRA. I believe there were some hotel workers who sued their overall company for not receiving their COBRA notices on time or in a language that they could understand. So regardless of the strength or weakness of the basis, you could still find yourself in court, and that's expensive, win or lose. And there's also civil penalties, private civil actions in state or federal court. And these are going to be levied on the employer, the plan, the insurer, or a third-party administrator. So one of the things that I ask my clients to do is to, if they don't have if they're not administering their own COBRA and it's done by a third party, that they look at their contracts or agreements with their TPA to see what sort of indemnification the TPA will provide if there is any negligence on their part in getting these notices out on time, such that they'll be responsible for it and they'll pay the penalties. All right, what you're all here for, the COBRA subsidy. I hope I've given you enough of a background that you understand what we're going to be talking about going forward. So this COBRA subsidy was part of the American Rescue Plan Act, the ARPA, and it was signed into law on March 11th. And the ARPA is huge and it has a lot of provisions, but this was the one that really was of most interest, particularly to employers and employees. It creates a 100% COBRA subsidy and additional enrollment rights for employees and their dependents who lost their coverage due to an involuntary termination or reduction of hours. Now, regular COBRA, you just have to have a termination. It can be for any reason. It doesn't have to be voluntary, it doesn't have to be involuntary. It's just straight termination. But for the subsidy, it has to be involuntary. And we're going to go into what that could mean in a few slides, but it has to be involuntary. And there has to be a reduction there has to be a reduction of hours. Now, the big question, do I have to pay for it all the way across the board? The answer to that is no. It's only 6 months from April 1st through September 30th. And there are ways that can end earlier than that. But that is the only period of time that the subsidy is 100% or that there is a subsidy. Now, could this be extended by another act or action by the government? Absolutely. But right now, as things stand, it ends September 30th and it started April 1st. And then another portion of this law says that plans may, but they are not required to, they may allow people eligible for the subsidy to switch between plans. Now, I understand that gives people some hives there, but the caveat is if you let people do this, they can only switch to a plan that is equal or of lesser value. So you can't switch up into a plan that's a Cadillac, because I know I would do that. Everyone would do that because it's 100% subsidized. No, if you want to switch your plans, you can go to A to B, but only if B, it costs you the same or is a little less cost. Now, just anecdotally, most of my plans that I represent have just thought that this was too much of a headache. And anecdotally, I have one plan that says, okay, if you go to a lower plan, we'll let you do that. And I believe the idea is to reduce cost. Now, involuntary termination, as of yesterday at midnight, we still don't have any guidance from the government about what involuntary means for the 2021 COBRA subsidy. We just don't. Now, I'm going to go into what happened in 2009. For those of you who are around this benefits industry back then, in 2009, because of the economic downturn, the government also put into place a COBRA subsidy. Now that one was only at 65% for involuntary terminations. That's all it applied to. It didn't apply to a reduction of hours. So we're not going to see much guidance from 2009 regarding a reduction of hours. So what I'm going to do, and please keep in mind that this is from 2009. This has not been brought forward yet by any branch of the government, the DOL or the IRS. So in 2009, the American Recovery and Reinvestment Act, again, they created a COBRA subsidy. Now I went back and looked at the guidance, and I'm gonna have to say a lot of the language for the 2021 COBRA subsidy is pretty much the same. So I am not going to say that this is 100% what we are going to see in terms of the definition of involuntary, but given that a lot of this subsidy is drawn from 2009, it would not be unreasonable to say that there's a strong possibility that we'll see this. So in 2009, there was an IRS notice, and involuntary was very wordy. And I have the whole quote there. Due to the independent exercise of the unilateral authority of the employer to terminate the employment, other than due to the employee's implicit or explicit request, where the employee was willing and able to continue performing services, which is a long way of saying the employee didn't want to stop working, but the employer said, you're terminated. So in that same notice, they gave a few examples of what involuntary would mean for the purposes of the subsidy. Failure to renew an employee contract where the employee was willing and able to continue working. Termination for good reason or for cause. A layoff period with a right of recall or furlough. And a resignation because of a material change in the geographic location of the employment. Your employee lives in California and you're relocating everything to Texas. The employee back in 2009 was allowed to consider that involuntary, and they would have been eligible for the 2009 subsidy. Now, these are the two most, one of these have already gotten a couple of times, and one of these is pretty related. So what happens if someone is given a severance package or retires? Now, under the 2009 rules, remember, these have not been brought forward yet. If the employer would have terminated the employee anyway, and the employee knew that, then and they chose to retire, then that retirement would be considered involuntary. So they would get the subsidy. Again, this was a 2009 rule. We haven't seen this yet for 2021. Now, in terms of a severance package, if an employee knew they were going to be terminated anyway, or if the employer announced that after a severance package offer period had passed, they were going to lay off employees, then taking the termination election and the severance package would be considered involuntary. And again, they would have been in 2009 eligible for that COBRA subsidy. Now we're jumping back into 2021. So on April 7th, there was a release of FAQs. And I have to say, it was mostly geared towards questions and answers that would be for employees about whether or not they could be eligible for this COBRA subsidy. But there was a little bit in there for employers in terms of implementation. And the big one is a reduction of hours doesn't have to be involuntary. There were some questions about that. If you're forced into part-time status, does that mean you get the subsidy, but if you decide to cut your hours to take care of family because of the COVID emergency, would that be enough to get you that COBRA subsidy. And what the FAQs made very clear is that a reduction in hours does not have to be involuntary. So if you have an employee who decides to reduce their hours so that they can go take care of their children or take care of a sick family member, then they're eligible for this subsidy. But it can also be a change in business hours, a temporary leave of absence. So if they decide to go on a leave of absence, or participation in a lawful strike. So one of the things that I'd like to see more guidance on is that temporary leave of absence. Does it apply to federally protected leaves of absence, such as the FMLA, or can it also apply to employer leaves of absence? Because sometimes employers say, go ahead, you can go on a sabbatical. You'll still be employed, but you won't get A, B, and C. Because that's not a federally or state protected absence. Would a leave of absence due to that be covered by the subsidy? I do not have an answer to that, but considering that the government really wants to keep people covered, I think, and this is just an opinion, this isn't legal advice, I think it's better to be safe than sorry and consider that a leave of absence for the COBRA purposes. All right, so this is another hot topic. So who's paying for this? As we saw, COBRA is expensive, especially the disability COBRA. So the payment is as follows. If you're an employer with if you're a single employer with a self-insured plan, and by self-insured, I mean you assume all the risk for the plan. You're not only collecting premiums, you're paying them, and you're making decisions regarding plan benefits, etc. So if that's you, you are, as the employer, fronting that COBRA subsidy. If there is a multi-employer plan, then the multi-employer plan itself pays for the subsidy. And if it's a fully insured plan, and by fully insured, I mean the insurer has its own network, makes its decisions, and all you're doing is sending a premium to it, and you're not assuming any risk, that's a fully insured plan. And so for that plan, the insurer pays the subsidy. Now, if someone is eligible for this subsidy and I'm going to say this now, this went through really fast. So there's going to be a lot of people who are paying for the COBRA, self-paying COBRA right now as of April 1st, who are going to be eligible for this subsidy. So when you run across one of those people, you have to refund them. And there's a period of time in which you have to refund them. And that's 60 days from when the payment was made. Not from discovery or your discovery that they were eligible. It's 60 days from when it was made. And so that's going to make it key that you get these notices out as soon as possible. Now, if you refund them, then that still is a reimbursable payment. So you refund them and then you can claim the reimbursement. There we go. There's my mouse. So the subsidy is going to be reimbursed by the IRS, and it's going to be a credit against your Medicare hospital insurance payroll tax, and will be, if there exceeds what you are to pay in payroll tax, it's going to be treated as a refund or an overpayment. Now, what about plans such as multi-employer plans that do not have a payroll tax liability? Very good question. We need a little bit more guidance on that. Anecdotally, I spoke to a multi-employer plan on Friday, and the executive director let us know that when this happened in 2009, they did pay it and they claimed it through their own multi-employer payroll tax. I don't know that's how it's going to be handled going forward, but that's what happened in the past. So we do need additional guidance regarding filing for the reimbursement. And again, it's going to have to be paid and refunded to a multi-employer plan, but as they don't have a payroll tax liability, well, we're waiting for additional guidance on that. And just by a side note, you can apply for an advance. I'm not going to talk about that. I encourage you to talk with your tax representatives and particularly about the advance and how this is going to be paid. So who's eligible for this subsidy? Basically, any qualified beneficiary already enrolled in COBRA, and we went over that: spouse, dependent children, the employee. Now, one thing that I need to bring up is that in some states, people who are not qualified beneficiaries, not a spouse, not a child, are offered COBRA. And I'm going to use my home state. In California, employers, now this is how they get to the plans. They're not going after the plans, they're going after employers. In California, domestic partners have to be treated the same as a married couple, which is why you will see in California that healthcare plans offer COBRA to domestic partners. But because domestic partners aren't qualified beneficiaries, if they are offered COBRA and are eligible for the subsidy, you will not be reimbursed. As the law currently stands, you will not be reimbursed for the subsidy given to a domestic partner. Now, it doesn't necessarily only have to be a domestic partner. There's legislation that is floating around and not quite passed yet on state levels that would say people can enroll their parents in their healthcare coverage. And under COBRA law, as it currently stands, they would not be qualified beneficiaries. So it doesn't just have to be a domestic partner. So just be aware, if you're giving COBRA to domestic partners and you give them the subsidy, and I encourage you to speak with your own legal counsel about that, but it is certain you won't be reimbursed for their subsidy. So here are your groups: people already enrolled in COBRA, people who are terminated, who are involuntarily terminated or have a reduction in hours after April 1st, and employees who are involuntarily terminated or experienced a reduction in hours prior to April 1st. So present, future, and past. So if we're talking about people who are eligible prior to April 1st, 2021, they can elect the subsidy even if they didn't enroll in COBRA when it was first offered, or even if they enrolled and then later dropped it. And a lot of people drop it because it's just too expensive. So they still get to elect the subsidy. They still have to be in their COBRA period. This subsidy did nothing to lengthen COBRA periods. It's either 18 months or 36 months. Nothing else happens. There's no, oh, okay, here's the subsidy, you get an extra 6 months. No, you have to be in your 18-month or 36-month period after April 1st in order to get this subsidy. And you have, it starts April 1st, and you have 60 days after they're provided with notice to elect it. It has to be an affirmative election. They don't just get it if they're in COBRA. No, they have to affirmatively elect it and show that they were involuntarily terminated or had a reduction of hours. I've already had the question, well, I retired and now I want the subsidy. Were you retired or did you retire? If it was a voluntary retirement and you could have worked if you still wanted to, you're not eligible for the subsidy. Well, I quit. Do I get it? No, you weren't involuntarily terminated. You don't get the subsidy. So really, anyone can apply, but only the people who actually meet the statute's requirements are going to get it. Again, dependents are eligible for this subsidy, and they have an independent right to elect this COBRA subsidy. But again, going back to our regular COBRA rules, they had to have been enrolled in the health benefit plan immediately prior to the employee's involuntary termination or reduction in hours. They had to have been in the plan. If they weren't in the plan and now they want the subsidy, too bad. They had to have been in the plan before the termination or the involuntary termination and reduction of hours. This is also something that wasn't addressed in any guidance, but I did reach out to the Department of Labor regarding this question. And take this with a grain of salt, but I was told by a Department of Labor benefits advisor on April 8th that plans have to look back farther than 18 months. And this goes back to the second qualifying event for spouses and dependent children. So the look back is 36 months, possibly a little bit sooner, just to make sure they still have time on their COBRA period, to find voluntarily terminated employees or who experience a reduction of hours. And then you need to see if there was any sort of event that extended a dependent's or spouse's COBRA period by another 18 months. And again, that has to extend past April 1st. So election period, again, they have 60 days after the date they initially received their election notice, or they don't have, or they forfeit their right to the subsidy. Again, there are people who are going to come in late and they're going to have to be refunded if they're already in COBRA. So the sooner the better on getting those notices out, and the sooner and better that you locate people who have self-paid so you can refund them. Now, here's an interesting situation. Someone who's eligible for the subsidy can drop coverage in the individual marketplace. So if they're in the marketplace and they have coverage, they can drop that coverage and elect COBRA and get the subsidy. Now, they lose any sort of other subsidy they were getting for the government to pay for that coverage. And I believe that once this COBRA subsidy terminates September 30th, they should be able to get back into the marketplace. But again, that's just something to be aware of when you're sending out notices. All right, on to the subsidy period. Maybe I've kicked this horse one too many times, but it begins April 1st and it ends September 30th. It can end earlier. So it's the earlier of September 30th when the COBRA period ends, or when the individual becomes eligible for Medicare or other health coverage. Remember, under the normal COBRA rules, they have to be enrolled. They have to actually enroll in Medicare or enroll in other health coverage. Here, they just have to be eligible. They don't necessarily have to enroll. They just have to have the opportunity to enroll in Medicare or another health plan. So this can be quite challenging. So I'm giving some very, very basic examples. I'm not going to go too far into things. So the first one, I think the simplest one, is you have a single employee. They had a termination date of December 30th, and they didn't enroll in COBRA effective January 1st when they could have. And their 18 months ends on June 30th, 2022. And they meet all of the COBRA requirements, subsidy requirements, involuntarily termed, reduction of hours. So what do they get the COBRA subsidy for? They only get it from April 1st to September 30th. No earlier, no longer. So only 6 months. Now, what I'm hearing is that because ARRA plans are subject to other COVID emergencies that allow people to elect, let's say, COBRA longer than the normal election period, they can, but don't have to, retro self-pay for January, February, and March. For non-federal governmental plans, we just don't know. They're not subject to those same extended election periods under ARRA. So that's an open question. But the consensus among attorneys right now is that they can go back and retro self-pay, let's say for January, February, and March. If that changes, I'm sure you'll hear about it. But if the employee decides to stay on COBRA after September 30th, then it's all self-pay. That's it. No more subsidy. So anything October through June 30th, 2022 is on their own dime. All right, another example of someone who, a qualifying employee, qualifying event prior to April 1st. Let's say an employee with dependents has a termination date of June 30th, 2018. Now see, I'm going back a long time. And they had a dependent who experienced a second qualifying event, let's say a divorce, or they aged out during the first 18 months of COBRA coverage. So they still have time in their COBRA period after April 1st. So let's say their 36 months ended on June 30th, okay? They only get the subsidy from April 1st through June 30th. They don't get it any longer than that. Remember, the subsidy did not extend any COBRA periods. The COBRA periods that originally appear in COBRA stayed the same. So if in this event, the dependent, Their COBRA 36 months ends June 30th. That's when the subsidy ends from them. They don't get to go through September 30th. So that's it, no more. Now, what if someone has a qualifying event after April 1st? That's going to happen. I don't know how often, but it's going to happen. So they have a termination date of May 30th, 2021, and their COBRA period effective date is June 1st. Their maximum COBRA period ends November 30th, 2022, and we're not going to talk about any secondary events. So for this employee and their dependents, or with or without, the COBRA subsidy period starts June 1st and ends September 30th. It doesn't start earlier. They can't retro back to April 1st. It starts June 1st. And again, if they want to stay in, they'll have to self-pay after September 30th. I feel like that was a lot. Now, going into the subsidy model notices, the Department of Labor was nice enough to post model notices after April 1st, of course, but they posted them. These, just keep in mind, these are not a one size fits all. There's a general notice, and that's for people who had a qualifying event after April 1st. So there's a general notice. There's also a notice for an extended election period for people who had a qualifying event prior to April 1st. And there's also an alternate notice. And remember, I said that federal COBRA only applies to employers with 20 or more employees, but that some states like California and Arizona, and I'm sure there's a couple more out there that I can't think of, have mini COBRAs, where the state says, okay, even if you're not subject to federal COBRA, we have a state COBRA. And so that alternate notice is for those mini COBRA state requirements. And then there's a notice of expiration of period of premium assistance. And then last but not least, a summary of COBRA premium assistance and forms. Now that goes with the first three notices. Obviously, you're not going to put an election form with the notice of expiration. So it goes with the first three forms. General notice, individuals who are involuntarily terminated after April 1st. We already talked about that. They can be provided separately or with the standard COBRA notice. Now, keep in mind, some courts have said, or at least one that I know of, has said that providing all these COBRA notices separately is just overwhelming and is not reasonable. So my recommendation would be that all COBRA notices be sent together and combined where possible. That is up to you. Remember that I said use of the model notices is considered best practice. Now these have to, they're by statute, they have to include certain information. So if you are going to draft your own and not use the model, you need to talk to your attorney about making sure that those self-drafted notices have all the required elements. The extended election period notice, again, this goes to people who had a qualifying event prior to April 1st. And these have a deadline. They have to be delivered by May 31st. So we're getting up there. It's time to start sending those out. Now, when this first came out, I was saying, okay, you know, we can just go back in time and target people. Given the penalties and the fact that people can terminate their individual marketplace coverage to come back in, and also because they have to affirmatively elect the subsidy, it might be prudent just to send those out to anyone who had a qualifying event in prior to April 1st within that 36-month period. That way it's better to be safe than sorry. Administratively, is that more work? Yes, but it's probably cheaper than any sort of penalty. And again, the alternate notice, I should have stated this up front, but I have it here. These mini COBRA rules only apply to fully insured plans. There's a whole lot of background about how the federal government can't take over health plan for private fully insured plans, and those are legislated by the state. We're not going to go into that, I promise. But if they're in a fully insured health plan in one of these mini COBRA states, then this is the notice that those employers would send out. The model COBRA subsidy notice, again, using the model notices is best practice because the government considers this good faith compliance. So the notice of expiration of period of premium assistance has to be provided no earlier than 45 days and no later than 15 days prior to the date that their subsidy would expire. So if you have someone who is going to have this premium subsidy end early, let's say June 30th, it's not just for the September termination, it's also for June 30th. But I'm going to go ahead and use the subsidy termination date. So no earlier than 45 days, so no earlier than August 16th, but no later than 15 days prior. So no later than September 15th. So that's a very simple example right there. Now, here's a summary of COBRA premium assistance and forms. This summary is where all the forms are going to be located, and it communicates information to the AEI, I think that is so unwieldy. So the eligible individual about the subsidy, eligibility, election timelines, and instructions for electing the subsidy. Again, it has to be provided with the general, extended, and alternate notice. Now, the first form is request for treatment as an AEI, again, very unwieldy, and that has to be completed and submitted to the employer, the plan, the insurer. Affirmative election. Also on that form at the bottom is a box where the employer, plan, or insurer says denied or accepted. Now, they have to be provided with that denial, but there's really nothing other than the form. If you would like to create a cover letter to go with that, there's nothing preventing you from doing that. And that might give you a little bit more space to explain the denial, but I would keep it simple. But speak to your legal counsel about that. And there's a second form. It's the participant notification form. And this is something that the eligible individual is required to provide to the plan if they become eligible. Just remember, they only have to be eligible for Medicare or other group health coverage. So they have to tell you that they're ending early. And in those situations, you don't have to give them the notice of termination because they have to notify you of the termination. So what happens if they don't tell you? Because this money is being repaid by the IRS, the federal government would like to keep money that they're not obligated to send or to pay. So the penalty, if they don't notify you, is they're liable for a tax penalty equal to $250. Now, if that failure is fraudulent because they're eligible for another plan, but they want 100%, and who wouldn't, they're liable for the greater of $250 or 110% of the subsidy provided after eligibility ended. So it can get pretty high. But if there was it wasn't reported because of reasonable cause and not willful neglect, there's no penalty. I mean, we all like the example of someone who's in a coma and couldn't send anything in because they just weren't awake yet. So if there's good cause, they're not going to be penalized. If it's just a failure, it's $250. And if they did it on purpose, it's 110% of the subsidy. That is for the government to give more guidance on or figure out. Don't know, still waiting. Okay, that was a lot to go through. It was. So again, I'm going to go back to, there's a lot we don't know yet. So here are open questions. Remember that someone can be added to COBRA if they're born or adopted during the election, the COBRA period. So will they, because of we're in a special enrollment period, be eligible for the subsidy? Open question. Is there going to be anything in the future guidance, et cetera, that will reimburse plans for dependents who are not qualified beneficiaries? Think the most obvious, domestic partners, but what about states that require other people like parents or grandchildren to be enrolled in the employer's healthcare plan? Will there be a reimbursement for them? Will it also be available if it's extended to 29 months due to disability? Remember, that disability extension is 150%. And plans will be paying this and the government will be reimbursing this. Will the government make this subsidy available to people in that high cost group? Again, will future guidance mirror the COBRA subsidy guidance? I think the odds are good, but I can't promise anything. And then will there be an expedited appeal process for people who are denied this COBRA subsidy? Back in 2009, there was. If you were denied the subsidy, then you could send an appeal to the Department of Labor and they'd have to turn that around in about 15 days. We haven't heard anything on that. These are questions that I have sent to the Department of Labor. I have been bugging them and they promised me a webinar and it was just a rehash of what the law is. So I'm still waiting for answers to these questions. So next steps. Now would be a very good time to audit your COBRA compliance in general, just in general, because remember those penalties are going to apply to the subsidy. The notice requirements apply to the subsidy notices. Are you tagging the right qualified beneficiaries? Are you sending out notices on time? Have you put into place compliance with the ARRA electronic disclosure rules such that you can email these? Are you keeping records and tabs on how notices were sent and when? So right now is probably a really good time for some general COBRA compliance. Next, locate your potential eligible individuals. Again, as a matter of prudence, it would be wise to send all those notices out to anyone who had a COBRA event in the past. And I think it's easier to target people terminated or suffering a reduction in hours after April 1st. But it doesn't hurt to have your eye on who you can approve. So there's my 2 cents on that. Make sure you're getting those subsidy notices out. Remember, one size does not fit all. You need to walk through those because if you're not going to let people switch between plans, you got to take that language out. So take that to your COBRA administrator or your legal counsel to help you through that. If you're going to write your own, definitely work with legal counsel to make sure it meets all legal requirements. And continue to pay your premiums to insured plan providers. Yes, they're going to be providing that COBRA subsidy, but keep paying your premiums and making credits to your self-insured plans. Big question for self-insured plans. I get this a lot. So I have been telling my plans to contact their stop loss insurers to make sure that any COBRA claims under the subsidy will be covered. I don't think it's likely that they're not going to. One, they're lawfully within COBRA and they'd have to cover those claims anyway. And two, most, if not all, I would say all self-insured stop loss policies say that they will comply with federal law. Never hurts to double check, but I don't think they're not going to cover these things, but always check. Also see if they're going to attempt to charge you a higher premium just because people who weren't in COBRA may jump on and incur costs. So check with your stop loss insurers. At least that's what I tell my plans to do. If you have a third-party COBRA administrator, check with them, see what their indemnification language says in their agreement. Not a bad idea. And then document. The more you can show in the event that the IRS says, why are we giving you money for this person? Or just in general, the DOL comes in and says, you have COBRA violations or someone sues you or brings something, make sure that you have documented your due diligence and compliance. You want to have that available. And then last but not least, where can you go for more information? The DOL has set up a dedicated COBRA subsidy webpage. It's where you can find their model subsidy notices, the summary and forms. It's where you can find their FAQs. And then there's also a part on that page where you can just find general guidance about COBRA. There's a section for employees, and there's there's a section for employers and advisors. So it's a good resource to go through if you have any other questions and want to dig deeper into the nuances of COBRA. And with that, I am done.
Brandie, it's Karen. I do not have any questions in chat, but if anyone has any questions, if they'd use the chat function, we will gladly answer those. I recognize we're about 5 minutes over our time limit, but we've got a few minutes if you do as well.
I'd be happy to answer any questions, or if you're a client or a client of TED, I'd be happy to work with you. Or you can just email me. Again, it's not legal advice, and there will be things that change as more guidance comes out. And hopefully it comes out soon enough for you to comply with all those notice requirements.
Brandie, the comments in chat are you've done a fantastic job.
Thank you.
So I think with that, we can end the session. We did record this. We will send a link to everyone who attended, so that if you have anything you want to go back and check on, you can. And again, if you have any questions, please reach out to Brandie. Thank you so much, everyone, for attending. We appreciate it.
Thank you. Appreciate
Goodbye.
it. Bye.